doing? All right. Hello, hello. How's everybody doing? So we're gonna go over the checklist for independent contractors. You can find these checklists on Transaction Desk at with the AAR forms, Arizona Association of Realtors. So new real estate agents joining brokerage documents. You want to onboard them. So the agent onboarding checklist with document specifics. So number one, we're going to start with the independent associate agreement. This is going to be known as the policy manual acknowledgement. It's going to confirm the agent's independent contractor status and outlines their relationship with the brokerage. So basically, if you're a new broker and you're hiring agents, you want them to sign this document to confirm that they're working with your policies, and they're following your policies and procedures. It's going to include acknowledgments of the brokerage's policies and your procedures manual. So things to do, things not to do. Um, it's going to often have your commission split. What is the split like? Which covers office, also cover office conduct, ethical guidelines, and operational standards. It'll set expectations for compliance with state and federal real estate laws and policies. Then you want to sign the W-9 form. This is going to collect the agent's taxpayer identification number, called a TIN. Sometimes people call it the TIN. It's a taxpayer identification number. Typically a social security number, SSN, or employee identification number for reporting purposes. This is required by the IRS, so the brokerage can issue a 1099 NEC form for commission payments or other income paid to the agent. So who fills out the W-9? The agent. Who fills out the 1099? The brokerage. Right? So the brokerage is going to issue a 1099 to the agent at the end of the year, and then the realtor will fill out a W-9 to give to the broker, and then performs the transactions over the year, and then the broker will give you the 1099 to the agent at the end of the year. 1099 NEC, right, for commission payments or other income paid to the agent. So if you're a new agent, expect a 1099 NEC from your broker, at the end of every year. Commission agreement is going to outline the agent's compensation structure, including commission splits, bonuses, and any minimum production requirements. It's going to clarify payment timelines, how commissions are calculated, and any deductions. So if you don't turn in a document to your broker on a timeline, sometimes they'll take off like $100 or something like that. I know I got docked recently. This year I sold a property for $450K, and I didn't turn in one of my documents, so I got docked. Right, so an administrative fee or some sort of fee for not turning in documents on time, or expenses. Specifies any referral fees or overrides if applicable. You might have to sign an NDA disclosure, ensures confidentiality of client information, proprietary brokerage data, and trade secrets. It's going to restrict the agent from sharing sensitive information with outside parties, both during and after their time with the brokerage. Typically, what I've signed in the past is just manual agreement, W-9, and commission agreement. Usually the commission agreement is in the policy manual. Technology and resource use agreement details agents' access to brokerage-provided tools, technology, and resources. E.g., example, like the CRM system, listing software, transaction management platforms. So you may or may not have to sign these other extra documents. Establishes guidelines for the acceptable use of these resources and any limitations or penalties for misuse. Covers data security and responsibility for maintaining confidentiality of client data. Agency disclosure form clarifies the agent's role and obligations, as a representative of the brokerage. It's going to outline types of agency relationship. Example like buyer's agent, seller's agent, dual agency. The agent may enter into or on behalf of the brokerage, ensures compliance with state mandated disclosure requirements. Advertising and marketing agreement. This is going to define the agent's rights and limitations regarding the use of the brokerage's brand and marketing resources. It's going to set expectations for social media, print, and digital advertising. It's going to outline rules regarding the creation of marketing materials. Errors and omissions insurance acknowledgement is another important document you might sign. Confirms that the agent understands the brokerage's E&O insurance policy and what it covers. So if you make a mistake, are you covered under the errors and omissions insurance acknowledgement? Outlines the agent's responsibilities in the event of a claim or dispute, and any deductibles that may be responsible for. May include a requirement for the agent to obtain additional personal E&O coverage if necessary. Real estate licensing and verification. It's going to verify that the agent holds an active real estate license in good standing in the relevant state. Ensures the agent's compliance with any continuing education requirements and industry regulations. It may include a process for notifying the brokerage of any license renewal or status changes. Fair housing and anti-discrimination agreement. This is going to affirm the agent's commitment to upholding fair housing laws and avoiding discriminatory practices. It educates the agent on their obligation to serve clients equally, regardless of protected characteristics like race, religion, sex, disability. This is going to outline consequences for violation of fair housing policies. Termination or exit agreement. So this is going to specify the procedures and responsibilities for both the agent and the brokerage if the agent leaves. This is going to cover commission payouts, pending transactions, details, any restrictions on contacting past clients after departure, and requirements to maintain confidentiality. So this is just an outline, right? It just gives you some guidance in what is needed. There may be other forms needed depending on the transaction. If you have any questions, please consult your broker. The detailed checklist should ensure that the agent and brokerage are aligned on all key policies, procedures, and expectations from the outset of their working relationship. All right, so we're going to go over an example, Big Door Realty's independent associate agreement. See how that policy is outlined. So here, the agreement. So you usually start with the company name, some agreement I had to sign in the past. So this agreement made and entered into this date. So I agreed on this date, March 21st, 2024, by and between Big Door Realty, hereinafter referred to as broker, and me, thereafter referred to as an associate. So right now, I'm an associate. Okay. Whereas broker is now engaged in business as real estate broker in the state of Arizona and is duly licensed to sell, offer for sale, buy, offer to buy, exchange, list, or solicit prospective buyer and seller to lease, rent, or offer to lease or rent and negotiate the sale, purchase, or exchange of real estate. Broker does not participate in cemetery. Okay, so here's a key word here. If you want to do cemetery sales, can you do it? No. Why? Because your broker has to want to do it. So it says right here, broker does not participate in cemetery or timeshare properties or transactions or property management. So right here in the first page, it outlines that the broker doesn't do cemetery or property management or timeshare. So can the salesperson do it? No. A broker does enjoy the goodwill of the public and a reputation for fair dealing with the public. Whereas broker may maintain office or offices in said state, possess equipment necessary and incidental to the operation of said business, suitable to serving the public as a real estate broker. And whereas an associate is now engaged in business as a real estate licensee, duly licensed by the state of Arizona, and whereas it is deemed to be the mutual advantage of broker and associate to enter into this contract upon the terms and condition hereinafter set forth. Now, therefore, for and in consideration of the mutual covenants and promises herein contained, and each act done pursuant hereto, the undersigned hereby enter into the following articles of agreement. Article 1, independent contractor. So the first part of your independent associate agreement is the witness. Next one goes into the Article 1, independent contractor. So A, this agreement does not constitute a hiring by either party. The parties hereto are and shall remain independent contractors bound by the provisions hereof. Associate is licensed by state law and is under the broker as to the result of associate work only, and not as to the means by which such result is accomplished. This agreement shall not be construed as a partnership, and neither party hereto shall be liable for any obligation incurred by the other, except as provided elsewhere herein. Broker shall not withhold from associates' commissions any amount for taxes by any government entity. So, key thing here, does your broker hold taxes from your paycheck? No. So, do you got to pay the taxes? Yes. So, at the end of the year, you're going to have to pay your taxes. And you have to figure out what, talk to your CPA, certified professional accountant, on what that is. Article 2, sales effort. Associate agrees to proceed diligently, faithfully, loyalty, legally, and with the best efforts to promote the business of serving the public to the end that each of the parties hereto may derive the greatest benefit possible under the laws of the state of Arizona, and more importantly, must be fair and equitable to all parties in any transaction. Article 3, ethics and trade organizations. A, it is expressly understood that broker of Big Door Realty is a member of the National Association of Realtors. So right here, Article 3, it's just outlining that the real estate company is a member of NAR, National Association of Realtors, Arizona Association of Realtors, and any local real estate boards, and multiple list services that any associate producing more than 6 transactions per year deemed necessary for broker to join. As a result, thereto, broker and associate are subject to and agree to abide by the rules and regulations of those organizations and related organizations pertaining to ethics, conduct, by law, and procedures. Agent agrees to, within 10 days of commencement of this contract, will become and remain a dues-paying member of an approved association of realtors and multiple listing service in the state of Arizona. Okay, Article 3, Section B. Associate and broker each agree to conduct business and regulate habits and working hours so as to operate in harmony with current laws, policies, and rules and regulations as set forth by the Arizona Department of Real Estate. Again, associate and broker each agree to conduct business and regulate habits and working hours so as to operate in harmony with current laws, policies, and rules and regulations as set forth by Arizona Department of Real Estate, as well as to maintain and increase the good will, business, profits, and reputation of broker and associate. So, Article 4 talks about commissions. So, the commissions and fees for services rendered in the sale, purchase, rental, lease, or exchange of real estate shall be those mutually agreed to by broker and associate. In no event shall associate charge less than the minimum commission fee established by the broker without broker's prior written consent. Commission and fee, when earned and paid pursuant to this agreement, shall be paid only by the broker to associate and or referral according to the commission schedule defined for this individual attached hereto. So here it's not, you're not specifying a specific commission number. Like say some brokers, they say, okay, you can't charge less than 3%. Here it doesn't say that. It just says whatever's agreed to upon, that transaction. In the event that more than one associate under contract with the broker participates in the common sale and multiple claims are made for a commission thereon, broker will refer to the written instructions submitted by the associate whose name appears on the controlling document, i.e., listing and or sales contract, to determine how to distribute funds in the absence of any written instructions or as the result of any ambiguity in the terms of thereof. The broker shall have the right to determine in his sole discretion, right? The broker can determine in his sole discretion, the broker can determine that in their sole discretion, how the commission in question will be shared, right? So if the broker deems in their sole discretion, deems to how to divvy up the commission between two sales agents, they can do that. How the commission in question will be shared, if at all, among the claimants. In no event shall broker be personally liable to associate for any commissions not collected. So in no event shall broker be personally liable to associate for any commissions not collected. All right, so let's go to Article 5, right? V is going to be for 5. So we've had so far we read Article 1, 2, 3, 4, now we're on 5. All right, so the broker shall not be liable for any expenses incurred by associate. So the associate, we as realtors, we usually have a lot of expenses like business cards, things like that. So the broker doesn't handle any of that, or for any of his or her acts, including but not limited to E&O deductible. So if you mess up on a document, you have errors and omissions deductible. The expense of attorney fees, costs, title, abstracts, and the like, which must be, by reason of some necessity, be paid from the commission or are incurred in the collection of or the attempt to collect the commission, shall be paid by the associate. Article 6. Real estate licensees, bonds, and dues. Associate shall pay all costs associated with the maintenance of his or her own real estate license and or any associate fees unless otherwise negotiated. So who pays for the realtor's fees? The realtor. Who pays for any maintenance of the fee? The realtor, right? Broker's not going to help you out with any of that. Article 8, authority to contract. Associate shall have no authority to bind, obligate, or commit broker by any promise or representation unless specifically authorized by broker in writing in a particular transaction. Associate shall be and is hereby authorized to execute contracts of sales, purchase, rentals, and leases, and listing agreements for and on behalf of the broker as agent. After certificate to write contracts has been issued by broker, also 3 hours of contract writing class must be earned from a recommended accredited school of real estate. So this is authority to contract. So when you're getting your license, you need to have at least 3 hours of contract writing class. And I believe ADRE requires that as well. All right, Article 8, right? Article 765. So Article 8, listing, correspondence, records, and forms. Associate agrees that any and all listings or contracts of property and all actions taken in connection with the real estate business shall be taken by associate in the name of the broker. Completed listings or contracts shall be filed with the broker no later than. Okay, so completed listings or contracts shall be filed with the broker no later than 5, then it has in parentheses 3 business days after commencement. So it looks like that's a typo. So I don't know if you meant to put 5 or 3 business days after commencement of contracts or listings by associate. So after you've completed a deal, right, completed a listing or a contract, I would say you have about 3 to 5 business days to give all your documents to your broker. You can just email them over. Some have. So I've worked with the broker who just wanted me to email them, and then I've worked with another broker who wants me to put them in some sort of database. Right, just depends on who you're working with. All listings or contracts shall be and remain the separate and exclusive property of the broker unless otherwise agreed by the parties hereto. Any listings or contracts received by the broker that exceed the 5 and puts in parentheses 3 business day rule will be subject to a $250 penalty, which will be deducted from associate's next commission to be received. Wow. So if you don't give them the documents, what's the penalty? $250 on your next commission check. If no commission is received within 30 days, associate must pay a $250 penalty. So if you don't do a deal within the next 30 days and you didn't give them the documents when they needed, that $250 you got to pay up. Associate must give a broker a complete copy of a completed transaction for broker's file, and associate must keep a completed transaction file within 3 days of close of escrow date. The list of completed transactions attached as exhibits A through D. So again, associate must give a broker a complete copy of completed transaction for broker's file, and associate must keep a completed transaction file within 3 days of close of escrow date. So close of escrow comes, right? The transaction ended. That means close of escrow, right? You closed. Within 3 days of closing escrow, you need to give your broker all the files, and you need to keep a copy of all the files. List of completed transactions attached and as exhibits A through D. So, exhibit A, exhibit B, exhibit C, exhibit D, things like that. B, it is agreed by the parties hereto that all correspondence, documents, or information of any nature whatsoever concerning transactions handled by broker or by associate or jointly are and shall remain the property of broker. So again, it is agreed by the parties that all correspondence, documents, or information of any nature whatsoever concerning transactions handled by a broker or any associate or jointly are and shall remain the property of broker. So all the documents, they belong to the broker. Do they belong to the sales agent? No. The parties hereto shall mutually approve and agree upon all correspondence from the office of broker pertaining to transactions being handled in whole part by associate. The parties hereto shall mutually agree upon the forms to be used and the contents of all completed contracts and other forms before they are presented to clients for signature. Each listing or contract submitted to broker shall have the applicable listing check sheet or purchase check sheet or any other check sheet provided by broker, provided by Big Door Realty. So again, each listing or contract submitted to broker shall have the applicable listing check sheet or purchase check sheet or any other check sheet provided by broker, provided by Big Door Realty, filled out completely with the appropriate documentation attached. No commission will be paid to associate before all documentation needed for each file is received and approved by broker or coordinator appointed by broker. So, your broker is going to give you a list, a check sheet, and then you just fill out the check sheet and you give them all the documents. Before they can give you the commission check, you have to fill out your check sheet. All right, Article 5, 6, 7, 8. Now we're on Article 9. All right, then we got 10, 11. All right, so Article 9, escrow deposit. All earnest monies shall be deposited at once or by the end of the next business day into an escrow account of a bona fide title or escrow company. So, again, all earnest money. So when you get the earnest money, who do you give it to? Escrow, right? Give it to the escrow company. Associate shall secure a receipt or copy of same for immediate delivery to broker on all deposits. So again, you're working with the title company, right? They're the escrow company, title company, escrow company. Your buyer needs to give this earnest money. You direct them to put it into title, right? Put it in escrow. You give it an escrow company, and then you need the receipt from that title company. So you need to go ask that title company, hey, I need the receipt for my client's documented earnest money. Also, associates shall deliver a fax or email and receive confirmation of delivery to client. So again, also associate shall deliver a fax or an email, probably just email, and receive confirmation of delivery to client. So associate shall deliver email, so send an email and receive confirmation of delivery to client. No earnest monies and or deposits will be taken in the name of Big Door Realty. So no earnest monies and or deposits will be taken in the name of Big Door Realty. So when you get money, don't typically have your client to deposit the check of earnest money in the name of the title company. Title escrow. You don't need it not with the real estate brokerage, right? So when your client says, "Who do I write the check out to?" It's whatever title company you're dealing with. Title or escrow company. They handle all the earnest monies, and they typically cut the checks to the brokers, anyways. And then the broker cuts the check to the realtors. All right, Article 10, cancellations or listing, sales, and other transactions. Broker shall have the sole right to cancel any listing agreement or any other transaction on any property at any time by written notice to associate and seller, provided associate is in default of any term of this agreement or this agreement is terminated. So again, broker shall have the right, in their sole discretion, right to cancel any listing agreement or any other transaction on any property at any time by written notice to associate and seller. So you're the sales agent, you have a listing, and your broker cancels. Can you do it? Yes, it can, unilaterally. So that's cancellations of listing, sales, and or other transactions, right? Because the agent operates in the name of the broker. Everything you do is in the name of the broker, right? You work for your broker. You're an independent contractor who works for your broker. Article 11. All right, so 9, 10, 11. All right, litigation and controversies. In the event that associate does not wish to orally enter into the following actions jointly with broker, then associate hereby grants to the broker that power of attorney in his name, place, and stead to institute and or defend an action in a court of competent jurisdiction concerning commissions or other matter related to the conduct of such real estate business of broker and associate as have been pursued by the parties under this agreement, to conduct the same to a final decision, to negotiate settlements, to defend actions, suits, or proceedings pertaining to said real estate business, to employ counsel, and to conduct said matters in final commission in such a manner and upon such terms as the broker may deem expedient or desirable. What a mouthful. This is litigation and controversies. B, Article 11, Section B. In the event any transaction in which associate is involved results in a dispute, litigation, or legal expense, associate shall cooperate fully with broker. Whether associate is with Big Door Realty or whether associate has left Big Door Realty. So again, in the event any transaction in which associate is involved results in a dispute, litigation, or legal expense, associate shall cooperate fully with the broker, whether associate is with Big Door Realty or whether associate has left Big Door Realty. Suits for commissions shall, agreeable to the law, by maintained only in the name of the broker, and the associate shall be construed to be a sub-agent only, and shall otherwise be deemed to be an independent contractor and not a servant, employee, or partner of the broker. Associate shall bear all expenses connected therewith and shall reimburse any and all monies expended by the broker in defense of said dispute. It is the policy to avoid litigation wherever possible, right? So you want to avoid litigation if it's possible, and broker within his sole discretion may determine whether or not any litigation or dispute shall be prosecuted, defended, compromised, or settled, and the terms and condition of any compromise or settlement, or whether or not legal expenses shall be incurred, provided, however, that no compromise or settlement involving the payment of money or anything of value by associate or the foregoing of any commission or portion thereof due associate shall be accepted by broker without written consent of associate. Associate shall pay the deductible to whatever his or her commission split was for that contract. So Article 11, litigation and controversies, comes down to, if you got paid $5,000 for the deal, right? Say the deal was $450,000, you got paid 3%. So you made like 12,500. 80-20 split. Broker might have got like $2,000. You might have got $10,000, so you might have to pay back that $10,000. That's what Article 11 says. Article 12, default and hold harmless. Section A, the parties hereto mutually agree that if either party shall be in default of or breach any of the terms of conditions of this contract, and such default or breach shall result in any loss or damage to the other party, then and in that event, the defaulting party hereby agrees to pay to the other party any such loss or damage, and further agrees to hold harmless from any claim, demand, cause of action, or lawsuit which may result from or be caused by such breach of this contract. There is hereby granted to the defaulted party a contractual lien upon any sums due or owing to the other, or which may be collected by the defaulted party and subsequently be due or owing to the other party, to cover the items described in this article. If said sum shall not be liquidated in amount, then in that event the defaulted party is authorized to retain said sums until said claim, demand, or cause of action shall be consummated. Okay, Article 13, arbitration agreement procedure. In the event of a disagreement or dispute between associate and broker arising out of or connected with this agreement, which cannot be adjusted by and between the parties involved under the terms and conditions of this agreement, and involvement of dollar amount in excess of the legal maximum allowable for suit in small claims court, the parties hereto agree to submit such disagreement or dispute to arbitration in accordance with the rules, regulations, and procedures of the American Arbitration Association. Associate hereby agree to pay all costs in connection thereto and be bound by the decision of the arbitrator named by the above described arbitration body. Okay, Article 14, automobile. It is agreed that associate shall furnish his own automobile and pay all expenses thereof, and that broker shall have no responsibility therefore. So it is agreed that associate shall furnish his own automobile and pay all expenses thereof, and that broker shall have no responsibility therefore. associate agrees to carry an adequate amount of public liability insurance with a minimum limits of $1 million or $100,000, sorry, for each person and $300,000 for each accident, and with the property damage limits of $100,000. The broker shall be shown as an additional named insured in all policies. So again, the broker shall be shown as an additional named insured in all policies. Associate agrees to furnish to broker a copy of the declaration page certifying as to such insurance prepared by the insurance company within 5 consecutive days of agreeing to this agreement. No commissions will be paid until declaration page showing broker as additional named insured is provided. So this article, 14 automobile, seems to have some issues here. Okay, Article 16, termination. This agreement and the relationship created hereby may be terminated by either party hereto with or without cause. So, I mean, as a realtor, you can sever your relationship with your broker at any time. You don't need their permission. You just go in, just click a button in the ADRE website, and you sever your license. At any time upon written notice given to the other, but the rights of the parties to any commission or fees which accrue prior to said notice shall not be divested by the termination of this agreement. 15. Termination. This agreement and the relationship created hereby may be terminated by either party hereto with or without cause at any time upon written notice given to the other, but the rights of the parties to any commission or fees which accrue prior to said notice shall be not divested by the termination of this agreement, except as stipulated herein. A 30 consecutive day notice in writing by the associate or broker shall be noticed. If associate is in violation of this agreement, in violation of state laws, rules, and regulation policies, in violation of the Realtor Code of Ethics, or any Realtor Association rules, regulation, or policies, the broker may terminate immediately. Upon termination of this agreement, all negotiation or contracts commenced by associate during the term of this shall continue to be handled through broker and with such assistance by associate as is reasonable under all the circumstances. Upon termination of this agreement, associate may preserve his or her right to receive commissions as outlined in this agreement by remitting the administration fees in the amount and by the due date contained in the applicable commission schedule for the duration of any pending transaction in which associate has established an interest. If for any reason associate fails to act in accordance with the terms of this agreement, or it is otherwise determined by broker that associate unable to act in accordance with the terms of this agreement, then associate will be in breach of this agreement and thereby cause his or her waiver of all rights to commissions otherwise payable to associate had that breach not occurred. In case of breach by associate, broker may, in his sole discretion, right there it goes again, broker may, in his sole discretion, assign the transaction to another associate, called the assignee. So, say your realtor dies. Does the deal die? No. What does the broker do? The broker just assigns it to another realtor. So the broker, in his sole discretion, assigned the transaction to another associate, called assignee. He'll assign the deal to someone else to service the transaction to its final outcome. So again, if the realtor or the listing agent dies, what does the broker do? The broker simply just assigns it to someone else in the brokerage. In the event all commissions, less those amounts due, broker from defaulting associate may be paid to assignee, subject to the terms of assignee's commission schedule, or will be determined by the broker. Okay, so this is Article 15, and basically, if you sever your license with your broker, and you have several deals in the pot, what happens? The broker can just assign those deals to another associate, another assignee. That's what this termination clause is about. Upon termination of this agreement, associate agrees not to furnish to any person or entity engaged in the real estate business any information concerning broker and or his or her business. All listings initiated by associate shall be screened separately and individually and may be released or canceled by the broker. All right, Article 16, miscellaneous. Heirs, successors, and assigns. This agreement shall be binding upon, and the benefits shall inure to the heirs, successors, and assigns of parties hereto. Notices. All notices provided for under this agreement shall be in writing and shall be sufficient if sent by regular mail to the last known address of the parties hereto, or to such other address as shall be designated in writing to the other party. Governing law. This agreement shall be governed by the laws, rules, regulation, and policies of the state of Arizona. Assignment. So we're still in Article 16, Section D. Assignment. This agreement may not be assigned, sold, or otherwise conveyed by associate. So this agreement may not be assigned, sold, or otherwise conveyed by associate without broker's prior written consent, but may be assigned by broker to any successor of his business. Waiver. That the failure of any party hereto enforce at any time any of the provisions or terms of this agreement shall not be construed to be a waiver of such provision or terms, nor of the right of any party thereafter to enforce such terms or provisions. Entire agreement. That this agreement constitutes the entire agreement between the broker and associate, and that there are no agreements or undertakings concerning such agreement which are not full set forth herein. Severability. That if any provisions of this agreement is invalid or unenforceable in any jurisdiction, the other provisions herein shall remain in full force and effect in such jurisdiction, and shall be liberally construed in order to effectuate the purpose and intent of this agreement, and the liability or unenforceability of any provision of durability or enforceability of any such provision in any other jurisdiction. H references that all associates shall provide at least 2 separate individual references for emergency use with the correct and current address and phone number with this mutually signed agreement. Amendments to this agreement. That there may be amendments to this agreement if in fact there are changes in state laws, rules, regulations, or policies. If there are changes in realtor ethics, rules, regulations, or policies, there may be changes between broker and associate if there is a mutual agreement to do so. Article 18, Errors and Omissions Insurance. The errors and omissions insurance carrier shall be chosen at the sole discretion of the broker. So at the sole discretion of the broker, they can pick, who's going to carry the insurance, the errors and omissions insurance. Associate is responsible for the deductible amount. Currently, it's $5,000 for each error and omission claim based on the commission split at the time and transaction the associate was receiving fees for. Associate shall immediately notify broker of any circumstances likely to give rise or claim of any kind. In the event of any claim, lawsuit, license, complaint, or arbitration demand which is not wholly covered by Big Door Realty, E&O Insurance associate is responsible to satisfy any amount not covered. Broker may also deduct the aforesaid amount from associate commission. Associate agrees to reimburse and indemnify broker for any and all attorney fees incurred by broker to obtain legal advice concerning such transactions. If there is an outstanding amount owed to broker, associate will allow broker to file a notice of default in the county and the state in which the associate lives. Whereas both parties, broker and associate, agreeing to the above agreement are declaring that they are of full and sound mind. Okay. The Big Door Realty Policy Manual, who was written by Richard Quintero, who's the president. It's the current company I work for. So we're going over this Big Door Realty Policy Manual. So here, also incorporated within this agreement is the Policy Manual by Big Door Realty, and then we go through the Policy Manual. So Big Door Realty sets the following procedure guidelines, which are for the conduct for doing real estate business. This manual shall be attached to and made part of the broker associate independent contractor agreement, freely entered into by both broker and associate. So again, right up front, it's telling you that this is attached. This manual, right, the policy manual, shall be attached to and made part of the broker associate agreement, independent contractor agreement. So they come together. Freely entered into by both broker and associate. In the event a situation arises that is not covered herein, the broker's decision will be final in their sole discretion, right? Which means if they choose to. This manual may be amended from time to time as events warrant, and associates will receive a copy of any amendments, right? Amendments, right? Additional, if the broker adds anything on, right? They amend or they make changes, amendments. An addendum, right, would be add-ons, but amendments are changes, right? So any amendments, any changes. Big Door Realty. So one, may within 1 to 2 years provide and maintain an office for a broker, associate, and associates clientele. So may within 1 to 2 years provide and maintain an office for the broker, associate. Okay. Number two, will not tolerate um, or be associated with the use or possession of any controlled substances, drug, firearms, explosives, contraband, or anything determined to be illegal on any property listed. Will maintain a general business phone number, which will be answered 24/7. Any listing or advertising by associate must include general number and a direct number to that specific associate. May take listings in any lawsuit. May take listings in any lawsuit form approved by broker and may offer sub-agency to cooperating brokers, but will fully accept buyer broker participation. Will require associate to input listings according to ARMLS rules and regulations. All associates must be approved by broker to input listings. All broker or appointed coordinator must approve and review the listing within 48 hours. The associate is responsible for correct and accurate information. Any changes by seller must be in writing with change form and approved by broker within 48 hours. After approval, new printout must be changed into listing book. Any and all non-MLS listing must include written disclosure by seller that property will not be advertised in MLS. A $100 charge to the associate's commission if broker has to make or input changes on behalf of associate. So if the broker's got to come in and make any changes, they're going to charge you $100. So $100 charge to the associate commission. So, it doesn't matter if you're an associate broker, associate realtor. If you're an associate, right, that's what they're calling you, to the associate's commission if broker has to make or input changes on behalf of associate. 6 will follow Article 26 of the Arizona Constitution that allows the real estate broker and associate the privilege to draft without charge any documents listed incident necessary to a real estate transaction. With that privilege comes the responsibility and duty to explain the implications of those documents. Always encourage the advice of any attorney and any accountant or any other professional associated with a real estate transaction for the benefit of your client. 7 requires associate the use of the most recent standardized published forms established by the Arizona Association of Realtors and reserves the right to approve, edit, or reject or add any documents used by associate as deemed appropriate by broker. So you want to use the most up-to-date documents in AAR, Arizona Association of Realtors, and Transaction Desk. All completed contract listings or transactions must be submitted to broker within 3 business days. Okay, so now the typo is gone. In the previous document, it said 5, and then it had the number 3 listed there. So it said 5 and then number 3 business days. So it's actually supposed to be 3 business days of final signature or rejection. All sales transactions must be run through a title company unless all parties secure legal representation. In earnest money, funds received from the title company or legal representation shall accompany each purchase contract. So again, in earnest money, funds receipt, right? So it's very important to get that receipt from the title company. So a receipt needs to come from the title company or legal representation shall accompany each purchase contract. All earnest money funds must be written in title or escrow company name. So again, this is the second time. All earnest money or the funds must be written in title or escrow company name. Can it be written in the broker's name? No. Will not restrict the form of representation associates may offer to the public. Each associate is responsible for knowing and explaining the benefits and consequences of the form of agency employed. In all cases, all parties. So again, each associate is responsible for knowing and explaining the benefits and consequences of the form of agency employed. So we have EER, we have EA, right? In all cases, all parties to the transaction shall be made aware of the form of agency chosen. Where mandated by law or other applicable regulatory agency, written confirmation shall be made available to all parties to a transaction prior to execution of a binding document or in a manner consistent with the law. Expects all its associates to be familiar and responsible with all disclosures and disclosure areas. So WQARF, CERCLA, lead-based paint, swimming pool, Superfund, airport noise, etc., and supply buyers and tenants the proper disclosures when applicable. So ask the broker, basically. So you can always ask the broker what are the appropriate documents, and they'll give you a checklist, and then you kind of got to go through your checklist. Um, Expects all associates to be responsible for all fees and expenses included in maintaining an active state of Arizona real estate license, and must be a member of the Arizona Association, AR, National Association of Realtors, NAR, and Multiple Listing Service, MLS. Will maintain errors and omissions insurance for the coverage of all transactions allowable within the definition of the policy. A copy of the policy is available upon request. So, the policy manual. Should you be given the policy manual? Yes, but you got to request it. Each associate is responsible for payment to the brokerage of the required claim contribution immediately upon demand, in accordance to the commission split in relation to the transaction at that time. If more than one associate is connected with the transaction giving rise to an E&O claim, each one is individually liable to remit the required contribution. The contribution shall serve to offset the costs associated with services provided by the broker, counsel, and other necessary expenses, and is considered non-refundable. Each associate agrees to cooperate fully with ownership and management in the resolution of any complaint or litigation. Each associate is personally liable for any claim or loss that exceeds the limits of or is otherwise not covered by E&O policy. associate's liability to the brokerage services severance, survived severance. Each associate hereby grants the brokerage or owns or management expressly permission to withhold the E&O claim contribution from any commission or other income payable to associate through the brokerage upon written notice of a potential or actual claim delivered to associate. E&O and any applicable fees will be assessed for each associate connected with any transaction. E&O will be charged on all transactions over $750,000, and commercial transactions will be charged a premium of 10% for additional E&O coverage. So I know we haven't talked about commercial, but from this statement, it looks like Big Door Realty does commercial real estate. Commissions are divided between broker and associate as stated in the following commission schedule of the independent contractor agreement and or policy manual. So again, commissions are divided between the broker and associate as stated in the following commission schedule of the independent contractor agreement and or policy manual. We'll pay out referrals to licensed brokers only, and only with the W-9 form from referral brokerage. So brokers can be broker to broker, but they need what? They need a W-9 form. Copy of license and ID number must be received within 30 days or forfeit referral. All transactions, sales, purchases, rentals, leases, exchanges, etc. must be submitted at the times stated herein. If broker receives a closing package without all proper contract forms, it may delay associates' commission due and may result in associates' severance. All transactions must have the correct check sheet attached to transaction at the time stated herein. Commissions will be dispersed to associate within 72 hours. So here's the big one. Commissions will be dispersed to associate within 72 hours during regular weekday business hours of receipt of closing package with all applicable items on check sheet provided and received by broker or broker coordinator. So your broker right here has 3 days, right? About 72 hours, 3 days to pay you. So all transaction must have the correct check sheet attached to transaction at the time stated herein. So how many days does the salesperson have at the close of escrow to give the broker all the documents with the check sheet? 3 days after close of escrow. Then the broker has 3 days to give you your check. What if they don't? So it doesn't say here anything. All closing packages must be delivered to the corporate home office. So all closing packages must be delivered to the corporate home office. It says, do not fax transactions under any circumstances. All transactions are to be emailed to Richard at bigdoorrealty.com. All transactions are to be emailed to Richard at bigdoorrealty.com. So obviously he's the owner. He opened this company and he's hired brokers and other folks to work for him. All advertisements must be reviewed and accepted by the broker prior to releasing advertising. All advertisements must be reviewed and accepted by the broker prior to releasing advertising. So, couple things here. You got 3 days after close of escrow when you've finalized your listing to give to email, actually, Richard at bigdoorrealty.com. That's your email. And how much time do they have to give you your commission? They have 72 hours. Big statements here on page 9. On page 10, all buyers must review, accept initial date, and be given a copy or buyer attachment information, including but not limited to buyer inspection, mold, termites, roof agency, disclosure, etc., etc. This form should be reviewed at the time of purchase or prior to that time. A copy of this cover page of the residential resale real estate purchase contract must be in the package for review when submitted to broker within 5 days after buyer signs this contract. So it's a little confusing because you have to submit it to Richard at what is this? At Big Door Realty, but Richard's not a broker; he's just the owner, so he must be forwarding to the broker. You got 3 days after the close of escrow to submit the documents. Then they got 3 days to pay you. All associates who are, and also another thing it doesn't say, so if they don't pay you within, if you don't give them the documents within the 3 days, they're going to dock you $250. And if they don't pay you within the 3 days, your broker doesn't pay you within 3 days, it doesn't say anything that happens to them. I mean, you can always quit because they're not paying you in a timely fashion. You don't have to work for that brokerage because they're not paying you on time. But seems like the only recourse you might be able to do. So all associates who are unable to serve his or her clients for any reason must make arrangements for another associates to manage his or her business during the absence. Also, there may be extenuating circumstances where family members may inform the broker of an associate's absence. Associate must inform the broker, coordinator, or management in writing of the identity of the other associate managing which transaction within 24 hours of the absence. If the broker, coordinator, or management is required to become directly involved in a transaction as a result of associate's absence or neglect, 50% of the commission owed to the associate will be forfeited to the designee along with applicable fees. So if you're unable to act on the transaction, what happens? 50% of your commission goes to the other person who had to pick up your slack, pretty much. There may be extenuating circumstances where family members may inform the broker of an associate's absence. So if you all go on vacation and you can't do the work and someone else has to do the work, 50% of your commission is going to that other assignee. The brokerage does not promote and will not tolerate any type of discrimination, including but not limited to the following: race, color, creed, religion, age. So can you discriminate because someone's old? No. 70-year-old, 80-year-old, no, you can't discriminate. Age, sex, disability of any kind, of any time by an associate. If an associate is accused and or convicted of any kind of discrimination, of any kind, that will be grounds for immediate termination and will be severed from this brokerage. So if you're accused of and then you get convicted of, then the brokerage will sever their license with you. All associates must sign and date a W-9 IRS form and keep broker current on address. So say if you're a realtor and you move, do you need to provide your broker with a new address? Yes. And you also have to have ADRE within 10 business days of moving your new address. So go in to the website and just update it. If any associates quits, resigns, or is terminated, they do not receive any further compensation other than transactions already in process. So if it's already in process, so say you do a deal and you already have it listed, you can keep that commission, right? As soon as it closes. If you already have your document signed and it's already in escrow, right? It's in escrow, it's with title company, they already have the earnest money in there. You can keep that commission, right? And then you sever, right? But if you don't have any documents signed, you don't have any dealings with the broker, then you won't get any commission. So, keyword here, already in process, right? That's the keyword in this policy manual, already in process. All newly licensed or non-experienced associates must be mentored by the broker. So here's the key one here. So this is where you got to pay attention big time. All, number 26, is even in bold. All newly licensed or non-experienced associates must be mentored by the broker or by an appointed mentor. So do you have to be mentored by the broker? No. Can you be mentored by an appointed broker? Appointed mentor, yes. For the first 3 transactions. So, you get hired on with my brokerage. Do you need so again, it says all newly licensed or non-experienced associates. So say you just got your license, right? You haven't done any deals. You need a mentor, and for the first 3 transactions, they got to mentor you. But what if you don't have a lot of experience, right? It says non-experience, no experience, right? So I've done deals over the past 5 years. I have a lot of experience, so I would not count as a non-experienced or newly licensed. The mentor will receive 20% of the above mentioned associate's compensation for the training. So for your first 3 transactions, whatever they are, your mentor gets 20% of what you make, right? You get 80. Mentors must complete entire transaction and follow through. The following is an example. So here's the example for first 3 transactions with mentor. So the sale price, say you do a deal and it's 200 grand. The commission is 3%, right? Agreed by the seller. So what 3 times 2 is 6. 6 of 200,000. So that's $6,000, right? Because you got to remove a couple zeros, 2 zeros. So $200,000 list price, 3% of $200,000. 3 times 2 is 6. $6,000 is the commission. The split, i.e., 50% lead, so here it says split is it's 80-20. So 50% lead. So 90% of $6,000 is $5,400. The mentor, experience, knowledge, gets 20% of that, or $1,080. The gross commission before expenses now becomes $43.20. The transaction fee is $595, right? There's a transaction fee on your commission of about $595. So 43.20 minus 595 is 37.25. So that's paid to the new associate realtor. Paid to the new associate realtor. So that is the breakdown. So basically, you do the commission. Sometimes you got to remember what's the transaction fee, and this split of 50% lead. This is if they give you the lead. So typically, your leads you generate yourself. So this wouldn't apply if you got the lead yourself. This would only apply if you did not find the seller, right? Associates may sell or buy their personal properties. So again, big one. Associates may sell or buy their personal properties with 100% gross commission minus E&O insurance for fee and a transaction fee for a total of $595. So this is the big one, because some brokers will still charge you, but if it's your own personal residence. So what's nice about this brokerage, Big Door Realty, is that you can get 100% commission on your own property, right? So it says right here, line 27, associates may sell or buy their personal properties with 100% gross commission minus E&O insurance. So errors and omissions insurance, you got to pay on each transaction. Everybody does, right? What it does is errors and omissions just covers you on the transaction. If you make a mistake on any documents that you need, that's what that covers you for. And a transaction fee. The total is $595. So personal property is limited to associates, titled and recorded personal or investment properties. So if your mom has a personal property and you don't want to charge her commission, well, you're still gonna have to pay uh, your percentage to the brokerage, your split. Associates may sell or buy their personal properties with 100% gross commission minus E&O insurance fee and transaction fee for a total of $595. So what does this mean? You can sell your personal property and you will still get 100% commission, and you won't have to split it with your mentor. So personal project property is limited to associates titled and recorded personal or investment properties. Associate properties must be in a county recorded title for 180 days or more. Less than 180 days would be considered flipping and not be covered under E&O insurance. So if you own a property but it's less than 180 days, they consider that flipping and they won't cover it under E&O insurance. All associates will hold harmless Big Door Realty. All such transactions are to be treated the same as any other transaction with the same documentation required regardless of the circumstances, i.e. listing agreement, etc. If representing a client in a for sale by owner property, a commission agreement with the seller must be in place prior to offer contract submittal. Here's the commission structure is as follows. Regular sales and listings, 90%. So this is regular. This is the commission structure. 90% gross commission on self-generated transactions minus the $595 transaction fee. You got 60% gross commission minus $595 transaction fee on company generated transaction. Now, the transaction fee is really just to protect you and everyone else and the broker, um, because it's the errors and omission insurance. It costs about $600 per deal, right? 30% gross commission as a showing agent, referring agent on a closed transaction. So, if you do a deal and if you go as a showing agent, you're just showing the property, or if you're a referring agent, you get 30% gross commission, kind of like a referral fee. 5% is gross commission as a recruiting agent. So, um, say you recruit another realtor, right? You recruited a realtor to join the brokerage. What's your commission on that? You did work, you'll get 5% of the deal, right? When they do a deal. Flat fee listings, company generated transactions. So we talked about regular sales and listings, and also about flat fee listings. Company generated transactions, $750 with no transaction fee. Sale generated transaction, a flat fee minus transaction fee of $595. Listings over $750,000 require an E&O premium of 0.1%. So again, company generated transaction is $750 with no transaction fee. Self-generated transaction is a flat fee minus a transaction fee of $595, right? That's the E&O insurance. Company generated transaction, $750 with no transaction fee. Any listings over $750,000, that's going to require an E&O premium of 0.1%. So if you're doing big deals, the E&O insurance increases to 0.1%. All right, so regarding associate owners selling or buying their own properties, it is the policy of Big Door Realty that if an associate has not completed, here we go, if they did not complete the first of 3 transactions, that the agent must use a mentor for selling or buying their own property, and this transaction shall not count as one of the 3 transactions. Oh, okay, so that's kind of nice. So, say, you got your realtor license because you want to, that's one of the main reasons why people get, that's why I got mine. So, why'd you get your license? Well, I want to sell my own property and get 100% commission on my own property. Well, the policy for Big Door Realty is that even if you haven't completed your first uh, your first 3 transactions with your mentor, well, what happens then? You can still basically you can still get 100% gross commission on your personal residence, right? So regarding associate owners selling or buying their own properties, it is the policy of Big Door Realty that if an associate has not completed the first of 3 transactions, that the agent must use a mentor for selling or buying their own property, and this transaction shall not count as one of the 3 transactions. Right? It doesn't count. They don't count this one. They don't count this one as one of the 3, right? In that regard, the mentor shall be compensated a fee equal to 20% of the commission. Advertised and or based on 3% of sales price should no commission actually be generated on behalf of agent. The new associate cannot be reimbursed for school fees, for selling or buying their own properties, and must pay for their own signs, Also, an associate will be limited to 3 residential properties per year. Any more than 3 and any other type of property will be negotiated on an individual basis with the broker. These funds to be paid directly to Big Door Realty out of escrow to compensate mentor. So, if you want to sell your own property and you haven't done the 3 yet, well, will this count? Okay. So let's read it again. In that regard, the mentor shall be compensated a fee equal to 20% of the commission advertised and or based on a 3% sales price should no commission actually be generated. On behalf of agent, the new associate cannot be reimbursed for school fees for selling or buying their own properties and must pay for their own signs. Also, an associate will be limited to 3 residential properties per year. Any more than 3 and any other type of property will be negotiated to an individual basis only with the broker. So, say you own 5 properties, right? And you want to sell all 5 and not pay any commission to the broker. They're only going to let you do 3 out of the 5 unless you negotiate it. All right, so next up, we're going to go over the information and reference page. Information and reference page on the Big Door. This is part of the policy manual, page 12. So here you'll print clearly your name, address, city, email, for commission checks and 1099. You need your social security number, you need your date of birth, auto insurance, name, your office number. For emergency purposes, reference number 1, name, address, city, relationship. Reference number 2, name, address, city, relationship. Okay, next up we'll talk about W-9, right? So, the realtor fills out the W-9, gives it to the broker, and the broker gives back a 1099 form at the end of the year saying how much money that was generated. So here's the W-9. It is a request for taxpayer identification number and certification. So anytime, as a broker, you have like 10 realtors, you need to give them all 10, you need to go to all 10 a W-9 form that they need to fill out. So we're going to talk about the W-9. So here's the link. This link will give you all the information about the W-9. So always check the IRS website for the latest and greatest W-9 form. So this is a request for taxpayer identification name and certification. So Department of the Treasury, Internal Revenue Service. So go to www.irs.gov/form W-9 for instructions and the latest information. So you want to give the form to the requester. Do not send to the IRS. Okay, so the broker, me, I will send it to you, the salesperson, and you give the form back to me. Okay. So before you begin, for guidance related to the purpose of the Form W-9, see purpose of form below. So line number 1, name of the entity, individual. So that's your name. 2, business name, the brokerage name. 3, A, you'll check the appropriate box. 4, exemptions. 5, address. 6, city, state. 7, the listing number, requester's name. Okay, so here is the taxpayer identification number called the TIN. You'll enter your TIN in the appropriate box, or your social security number, or your EIN, your employer identification number. Note, if the account is in more than one name, see the instructions for line 1. See also what name a number to give the requester for guidelines on whose number to enter. Part 1, enter your TIN in the appropriate box. The TIN provided must match the name given on line 1 to avoid backup withholding. For individuals, this is generally your social security number. However, for a resident alien, sole proprietor, or disregarded entity, see the instructions for Part 1 later. For other entities, it is your employer identification number. If you do not have a number, see how to get a TIN later. Part 2, certification. Under penalties of perjury, I certify that 1, the number shown on this form is my correct taxpayer ID number, or I am waiting for a number to be issued to me. 2, I am not subject to backup withholding because A, I am exempt from backup withholding. I am a U.S. citizen. 4, the FACTA code entered on this form, if any, indicating that I am exempt from FACTA reporting is correct. Certification instructions. You must cross out item 2 above if you have been notified by the rest that you are currently subject to backup withholding because you have failed to report all interest and dividends on your tax return. For real estate transactions, items 2 does not apply. For mortgage interest paid, acquisitions or abandonment of secured property, cancellation of debt, contributions to an individual retirement arrangement, IRA, and generally payments other than interest and dividends, you are not required to sign the certification, but you must provide your correct TIN. General instructions. Okay, so you're going to sign there, date there. General instructions. Section references are to the Internal Revenue Code unless otherwise noted. Future developments. For the latest information about developments related to Form W-9 and its instructions, such as legislation enacted after they were published, go to www.irs.gov/Form9. What's new? Okay, so here they're going to tell you what's new in this March 2024 update. Line 3A has been modified to clarify how a disregarded entity completes this line. An LLC that is disregarded entity should check the appropriate box for the tax classification of its owner. Otherwise, it should check the LLC box and enter its appropriate tax classification. New line 3B. So if we go up to line 3A and 3B, that's new. Right? 3A, they did something with this, and 3B. Okay, so what's the purpose of the form? So an individual, also 3B has been added to this form. A flow-through entity is required to complete this line to indicate that it has direct or indirect foreign partners, owners, or beneficiaries when it provides the Form W-9 to another flow-through entity in which it has an ownership interest. This change is intended to provide a flow-through entity with information regarding the status of its indirect foreign partners, owners, or beneficiaries so that it can satisfy any applicable reporting requirements. For example, a partnership that has any indirect foreign partners may be required to complete Section K2 and K3. See the partnership instructions for Schedules K2 and K3, Form 1065. All right, purpose of the form. An individual or entity Form W-9 requester who is required to file an information return with the IRS is giving you this form because they must obtain your correct taxpayer identification number, TIN, which may be your Social Security number, individual taxpayer identification number, adoption taxpayer identification number, ATIN, or employer identification number to report on an information return the amount paid to you or other amount reportable on an information return. Examples of information returns include, but are not limited to, the following. Form 1099 INT, Form 1099 DIV, Form 1099 Miscellaneous, 1099 NEC. So right here, 1099 NEC, this is the typical form I have to give to you at the end of the year. It's a non-employee compensation, right? Because you're an independent contractor, you're not an employee, and I need your 1099. I mean your W-9, which will come with the social, and then I got to put the social on the 1099 to give to back to you at the end of the year to tell you how much money you earned. So all these other ones are applicable. Use only W-9 if you are a U.S. person, including a resident alien, to provide your correct TIN. Caution: if you don't return Form W-9 to the requester with a TIN, you might be subject to backup withholding. See what is backup withholding later. By signing the filled out form, you one, certify that the TIN you are giving is correct, certify that you are not subject to backup withholding, claim exemption, certify that your non-foreign status, certify that FACTA codes. All right, so for foreign persons, if you are a foreign person or the U.S. branch of a foreign bank that has elected to be treated as a U.S. bank person under Regulation Section 1.1441, non-resident alien. So here's an example. Here's backup withholding. What's backup withholding? Persons making certain payments to you must, under certain conditions, withhold and pay to the IRS 24% of such payments. This is called backup withholding. So payments that may be subject to backup withholding include, but are not limited to, interest, tax exempt interest, dividends, broker and barter exchange transactions, rents, royalties, non-employee pay. So that's backup withholding. All right, what is FACTA reporting? So it's the Foreign Account Tax Compliance Act. Right, Foreign Account Tax Compliance Act requires a participating foreign financial institution to report all U.S. account holders. Okay, updating your information. You must provide updated information. Any person to whom you claim to be an exempt payee, if you are no longer an exempt payee and anticipate receiving reportable payments in the future from this person. For example, you may need to provide updated information if you are a C corporation that elects to be an S corporation, or if you are no longer tax exempt. In addition, you must furnish a new Form W-9 if the name or TIN changes for the account. For example, if the grantor of a grantor trust dies. There's penalty if you fail to furnish the TIN. If you fail to furnish the correct TIN to a requester, you are subject to a penalty of $50 for such failure, unless your failure is due to reasonable cause and not to willful neglect. There's civil penalty for false information with respect to withholding. If you make a false statement on no reasonable basis that results in no backup withholding, you are subject to a $500 penalty. Criminal penalty for falsifying information. So willful falsifying certifications or affirmations may subject you to criminal penalties, including fines or imprisonment. So if you give fake information, you can go to jail. All right, so if the entity individual line 1 is a corporation, then check the box for corporation, line 3A. If it's individual or sole prop, check the box for individual sole prop. If it's an LLC classified as a partnership, LLC that has filed Form 8832 or 2553, electing to be taxed as a corporation, then check the box for limited liability company and enter the appropriate tax classification. P is partnership, C is corporation, S is S corp. Partnership, trust, state, trust, state. All right, if the payment is for interest and dividend payments, then the payment is exempt for all exempt payees except for 7. Broker transactions. If the payment is for broker transactions, then the payment is exempt for exempt payees 1 through 4 and 6 through 11 and all C corporations. S corporations must not enter. So part 1, taxpayer identification, enter your TIN in the appropriate box. All right, so how to get a TIN. If you do not, oops. How to get a TIN. If you don't have a TIN, apply for one immediately. To apply for a Social Security number, get Form SS5, application for a Social Security card, from your local Social Security office, or get this form online at www.ssa.gov. You may also get this form by calling 1-800-772-1213. Use Form W7. Part 2 is about certification. All right, real estate transactions. You must sign the certification. You may cross out item 2 of the certification. Other payments. What name and number to give the requester. So for this type of account, give the individual, 2 or more individuals, 2 or more U.S. persons, custodial account, the usual revocable savings. Okay, give the name and security number of the individual, each holder, the minor, the grantor, the actual owner, the grantor. For this type of account, disregard entity not owned by an individual. Give the name and EIN of the owner. For this type of account, a valid trust, estate, or pension trust, give the legal entity. Grantor, give the name of the trust. Secure your tax records from identity theft. Identity theft occurs when someone uses your personal information, such as your name, Social Security number, or other identifying information without your permission to commit fraud or other crimes. An identity theft may use your security number to get a job or may file a tax return using your Social Security number to receive a refund. To reduce your risk, protect your Social Security number. Ensure your employer is protecting your Social Security number, and be careful when choosing a tax return preparer. If your tax records are affected by identity theft and you receive a notice from the IRS, respond right away to give the name and phone number printed on their IRS notice or letter. If your tax records are not currently affected by identity theft, but you think you are at risk due to a lost or stolen purse or wallet, questionable credit card activity, or a questionable credit report, contact the IRS Identity Theft Hotline at 1-800-908-4490 or submit Form 14039. For more information, see Publication 5027, Identity Theft Information for Taxpayers. Privacy Act Notice, Section 6109 of the Internal Revenue Code requires you to provide your correct TIN to persons, including federal agencies, who are required to file information return with the IRS to report interest, dividends, or a certain other income paid to you. So if you're an independent contractor, you're going to get a W-9 from your broker, and your broker needs that W-9 so they can file their taxes, and they will give you back a 1099 NEC at the end of the year. Okay, let's go over the 1099 NEC. So 1099 NEC, this is just they've updated it. They've included this red thing. You don't need to do that. So here you're going to get this document right here. So it'll just have your payer's TIN or your social, recipient's TIN, payer's name, street address, city or town. It'll have how much you were paid, non-employee compensation, payment made, direct sales totaling 5,000 or more, consumer products resale. If they check that box, Form 1099 NEC, you should be getting this from your broker. Non-employee compensation, copy one for state tax department. The recipient's name, street, city, federal income tax withheld. So, every broker, if you got 10 licensees, you're going to need to fill out 10 of these for each one. State tax withheld, state penalty. So state tax withheld, usually it's zero. State payer state number and state income. So you'll keep that. It's the same. Instructions for recipients. So you received this form instead of Form W-2 because the payer did not consider you an employee and did not withhold income tax or Social Security and Medicare tax. If you believe you are an employee and cannot get the payer to correct this form, report the amount shown in box 1 on the line for wages, salaries, tips, Form 1040, 1040 SR, or 1040 NR. You must also complete Form 8919 and attach it to your return. For more information, see Publication 1779, Independent Contractor or Employee. If you are not an employee, but the amount in box 1 is not self-employment income, for example, it is income from a sporadic activity or a hobby, report the amount shown in box 1, line on Schedule 1, Form 1040. And that would be the rest of the NEC form. All right, so you'll have copy 1 and copy B for the recipient.